Welcome back, everyone, from lunch. I want to get us started picking up with the text where we left off. So, Jeff, I will hand it over to you. I just want to remind everyone that we want to make it through this so we can get to some caucuses this afternoon. So please share those clarifying questions and our showstoppers, as it's been put. Jeff, back to you.
Okay, we're going to start back up. Thanks for everybody for giving us a little extra time at lunch to do some other work and get things on track for here. We're going to go to page 72. And I'm going to get there too myself.
Going to give everybody a moment to get to page 72. Jeff, anything you wanted to say about this before I open it up to comments and questions?
No, I don't think there's any setup. We can go straight to that.
Perfect. Thank you. Jennifer, you have the floor.
So I do want to say this is much better than it was. So I appreciate the department hearing concerns raised. I am kind of curious why the department feels it needs H at all. We can talk about it another time, but I'm just still flagging it because to me, the agencies all do have ways for restoring. I think, I'm kind of looking at Michael and Rebecca, but I think that accreditors already do have ways for restoring accreditation. So this one feels like an unnecessary provision to me. There's the retro piece because it says retroactive.
Elizabeth?
Just really quick, I wanted to say I'm not sure that they all have restoration of accreditation policies. And then the reason that we added the applicable by judicial decision is, if there's a stay or something else to then continue that.
Yeah, I mean, right now, and so here's the problem we're trying to solve for. Right now, we don't have a mechanism to continue Title IV if there's a dispute going on, particularly if there's a pending action where a stay hasn't been granted yet. That would continue the funding. So this is to cover that interim period of time.
Okay, thank you, everyone. Jeff?
It doesn't change their accreditation status, too. That's the other thing. We're not overriding the or getting involved in that dispute.
I know that's the deletion that I appreciate because you were kind of before.
Thank you, Jennifer. Elizabeth, did you have something else?
Well, if we're going to move on, if nobody else has anything, I'll just really quickly at the bottom of 72, we added language that was, I think, inadvertently removed when we moved it from 18D to this section. And so added that back, but I wanted to point that out.
Thank you, Elizabeth. That's all the cards for now, Jeff, so I'll turn it back over to you. I'm sorry, I missed Magnus, please.
No, it's just a quick comment. I just wanted to express appreciation to the department for the portion of paragraph H that's been struck.
Thank you, Magnus.
All right, page 79, please. Beth has worked on this section with and coordinating the language per the comments we received at the last session on substantive change with our colleagues in FSA. So I want to turn it to her to walk us through the changes here.
Yeah, Jeff has, teed it up quite well in that, as we discussed at the prior session, there was a discussion on, are there areas of substantive change that can be notification only versus notification to the agency versus require accrediting agency approval. And so I worked with my colleagues at FSA to figure out which areas do we require accrediting agency approval in order to then be able to approve for Title IV purposes. So those are the changes that you'll notice is that there, I think, are 2, 3 things that we removed from the substantive change list that's under A2. And then we move those items under, I'm sorry, I'm scrolling down because I can't remember what under B, so that this relates to, so it's notification as long as the institution isn't in some sort of either probation or equivalent status, a negative action taken. This is all language that we had previously and that was removed, that we added that back in and instead had the notification for these areas. So it was the substantive change, any substantial change in the established mission or objective of the institution or its programs, a change in the way the institution measures student progress, and any substantial increase in the number of clock hours or credit hours. And then we also brought back to make a differentiation is that entering into a written arrangement under 668.5 that's up to 25%, they could just do a notification. But if you go back to new H, anything that's more than 25 but less than 50, that language still stays there. And then we also added AJ that talks about the addition of a first prison education program at the first 2 additional locations and the first prison education program offered by a new method of delivery, because those are requirements under prison education program regs that require the accrediting agency approval. And then there were a couple other items that were added based off of proposals from some of the negotiators to include a slight change to the language under the new A, which is any change in the legal status that results in a change of control. And then we also took, talking about under, it's related to the change of control, the new E, in the acquisition of a new institution or program that's not otherwise reviewed by a change of control transaction, so it's not duplicative work. And then also under new G, talking about the review of a new location or branch campus and what that review would be required. And that was based off of a proposal from the prior one from Mark Becker. And then I think those are all of them for that part. And then we just made obviously corresponding changes to the citations to make them accurate. So with that, and I will open it up to anybody with any questions.
Thank you, Elizabeth.
That's everything in 22. Yes. Covers a few pages.
Okay. Jennifer, please.
Actually, I'll let Monty go first.
Well, thank you very much. But ladies first. I'm kidding. All right. First of all, this section, the general tone I think that I have heard back from constituents is substantive change. The proliferation of the substantive change has been the challenge that many of our both agencies as well as institutions are challenged by. So I guess I noted the prison change that was referenced around prison education. Think about both dual enrollment as well as those sites out there that are industry oriented, particularly going to an employer site. I wonder if you can kind of help us to understand. I see that we dealt with the prison education piece. I see where dual enrollment could be improved a bit. I'm wondering if you can kind of help me to figure out what improvements have we made with this new language that specifically are going to help us to be able to take instruction out to locations without the additional step of substantive change at the level of review, et cetera. Does that question make sense?
I think so. And unfortunately, I don't think I'm going to give you an answer that you're going to like. FSA is really the driver of what locations have to be reviewed. And so agencies are then required to review the additional locations. So this defines what substantive changes are, but by and large, an additional location is going to be something that has to be reviewed for FSA purposes.
Sure. I think the irony of it is that these are locations that do not take advantage of Title IV because the employer is paying. And so this makes it even that much more difficult to put an excuse in front of an employer that has really no relation back to that employer. The question becomes, if we're really wanting to innovate, why are we tying the hands of institutions to go to places to teach and provide instruction that is in demand, employers are asking for, but yet our federal government that does not have a role in paying for that instruction is saying, nah, you got to go through an additional step. Does that make sense?
Yes.
Seems to stand in the way of innovation.
But, well, I would say that there is an option if the agency has it. So under C, which is
Right.
the bottom of page 84, that if the agency has already approved at least 2 additional locations and that they're also not in like a negative status, then they can do, they have to report these new locations within 30 days, but they don't have to go and do a separate site visit for that. So there already is leeway in that particular area already in the standards. In the regulations. It's just up to whether or not the agencies have adopted those.
So this is the cover that we use essentially today. So I guess what I was trying to get at is if indeed what we're saying is we want higher education to be more innovative and to take what we offer to the field, to people that need them in hinterlands of all kinds, then why in the world would we make it an exception rather than specifically making it easier to take instruction to people at locations where they are already living, working, playing, et cetera? Let's take education to them. Does that help to get to the point? I still think there's room for us to push a little further on the innovation side here. I would just ask for some consideration on that one as it relates specifically to the relationship between institutions and employers.
Well, Monty, we would be happy to have any language from you or anybody else who might have some innovative ideas in this area. We feel as the federal government, there is already quite amount of discretion, at least after the first 2. And so I would, defer to maybe talking with some of the accrediting agency representatives to ask them, why, because there are some agencies that do this and some that don't. And so it's an allowance.
Thank you, Monty. Thank you, Elizabeth. Jennifer, I'm back to you.
So in general, I like the principles around this section in terms of what you're trying to achieve, but I do have concerns about a couple of the changes. And so I think, Beth, you said something about like the sort of part of the purpose is being alignment with what current regs are, what you're also doing in terms of sub change, right?
You mean what FSA is doing?
Yes, sorry.
Okay.
You being the department.
Okay.
Sorry, not you
I thought that's what
personally.
you meant.
I know.
Yes. Okay.
But there's a couple, regardless of what FSA does or doesn't, there's one in particular for me that from an accreditation standpoint is something that should require sub-change approval by the agency in a process, which is the change in mission. It's the first one you deleted because the mission of an institution is so fundamental. And so you could have as a mission, we're an institution focused on public health. And then all of a sudden you change your mission to start teaching in a completely different space, right? And that, what you're telling me by this is that's just a notification or that's not a sub change in effect. To me, the mission is the foundation of what an institution is. Like they set their mission first. And so if you're going to change your mission, which is kind of a big deal when you change your mission at an institution. So I personally think that this is something that is a sub change. So I have real concerns over that one. I'm mildly interested, but so I'm not falling on my sword on it, but I do want to raise that I find it interesting that you also deleted like the changes in credit hour, clock hour modalities as
We didn't delete them. It's in 2 under.
well, you're moving, I'm
Yeah.
sorry, not deleting it, moving it to a notification only requirement,
Yes.
basically. Yeah. Because the department has talked a lot, this department and every department has talked a lot about time. And I mean, you did keep the credential level, which I appreciate. So I have some mild concerns about E being deleted and the changes in F, but my bigger one is the change in mission.
Okay, thank you.
Thank you, Jennifer. Thank you, Elizabeth. Jeff, I'm back over to you. That's all of our cards. One just went up though. Monty, please.
Just one other quick question. I guess it perhaps is for the accreditors at the table more so than the department, and that is as it relates to financial issues. Substantive change here references a whole range of different areas, and then we have financial stability. So I'm wondering, are there events from the history and perspective of the accreditors that should prompt some level of substantive change from a financial point of view?
Would anyone like to respond to Monty? Michael, please.
Under the substantive change provision, are you referencing when it talks about financial review for the addition of a branch campus or additional?
No, I'm just simply saying if there's an event at the institution that is financial in nature that needs to be reported to the accreditor.
Yeah, it's just not under this section.
Right.
It's under monitoring,
Got it.
which is, I think,
Sorry.
19.
Maintenance.
Yeah. So the financial monitoring and things that we have to do doesn't fit as, it wouldn't be considered a substantive change. We would only, well, not only, we typically review the financial piece of it as the kind of the context with whether or not the institution has the resources to undertake the substantive change. So we may look at their latest financials if they're wanting to add a branch campus, right? I mean, if there's a going concern or something that obviously would be viewed negatively. If they are under some kind of other kind of monitoring or action with the department, that would be an issue. So we would be looking at all of those things, but not as a triggering event. The triggering event would be the application for the substantive change itself.
Got it. So in the instance of maybe a bond rating downgrade, as just one example, that might be an event that would have a financial impact. And what you're saying is today that is not included as a change for the institution. It is much more on the monitoring side.
Right. Part of the annual monitoring. And then, Monty, I would just say, if I can steal the questions that you had around the issues or on the substantive change. If you've got some language you want to kick around, we're happy to take a peek at that and see if there's something, because your question around dual enrollment and wanting to get it out not only isn't really addressed here, but it also conflicts with some of the other language around other policies that agencies must have for the approval of programs and locations. And so we may be able to I had made a recommendation around striking some of that for that very purpose. And we talked about it the last time we were here. It wasn't accepted, but maybe there's a side door that we can try again and see if we are more successful with some other changes.
Thank you, Monty. Thank you, Michael. Beth, before I move on, was there something you wanted to add to that?
No, I was just providing the regulatory citation of 602-19B is what Michael was referring to.
Thank you, Beth. Jennifer, please.
I just have a really quick question on the written arrangements, Beth, that you went through it, but that's just current regs that you're just putting into the appropriate location.
Yes, yes.
Okay.
There's no change to those levels or anything.
Got it.
Thank you, Jennifer. Thank you, Beth. Monty, did you have anything additional? No. Jeff, back to you.
Okay, we're going to skip ahead to page 94 at the top. The change from degrees to credentials, which was a suggestion. And then we have on the following page, we have a number of changes after that. Hearing nothing there, we can go to 95.
No cards, Jeff. As soon as I say that, every time. Jennifer.
I
Okay,
was waiting to see whether Jeff had any explanation.
you're perfect.
No, I'm sorry. So the first one was a suggestion by AD that we took, and I was just clarifying with Beth that this was the actual language. It wasn't one of these where it was a suggestion and then we close enough, right? Okay. AD, do you want to talk to that first before Jennifer? Or?
You want me to go first? It's up to you. Go.
If Jennifer, you asked the question, then I can clarify. You want to?
Well, I went and looked at your proposal
Right. It
and it's different.
is different. That's what the purpose of was a clarification. Sorry. And I'm looking just between the two language side by side. So in our proposal, it said the idea was to the original language said agencies must you're talking about the agencies must refrain from review of institutional governance. 98. That is the rightful purview of a state government. Our recommendation was to clarify and say that a public institution where such governance is established by state law, and the department added the rest of that sentence.
Do you have follow-up, Jennifer?
Yeah, my question was, so we got a little sidetracked on whose proposal it was. So the new part that's not ADs is including the appointment of institutional directors and officers by elected and appointed state officials. And to me, that's hugely problematic. Because I think the way I'm reading it is you're saying that an accrediting agency can't be reviewing the institution's board of directors at all if they're a public, in effect, if they're a public U. I just want to make sure, is that what you're saying?
That is what we're saying.
All right, well, I'll
That
hopefully.
state law is state law.
Well, it's not really, this isn't necessarily about state law. It's about the qualification. I mean, I think we have an interesting conflict here because we're talking about governance qualifications to run an institution. And so I think this is just an interesting, let's just say it's an interesting quandary. I'll leave it at that.
Thank you, Jennifer. Mark, you have the floor.
So first, just a technical clarification where it says the institution established by state law. I mean, some of these institutions predate the states. They were founded before the states. So do you actually have to go in and verify that there was a state law? I mean, yeah. So that's just a question of clarification there. Is that going to be a very strict definition, or so there are public entities that were formed before the territory in which they exist were officially states. So there may or may not. I don't know. I'm asking is that the level of technical detail you want to get into?
I think what we're talking about is what does current state law define in terms of the governance structure, and that essentially takes precedence over the accrediting agency's authority.
Okay,
over that
it's an
institution.
established state entity, the institution. Okay.
Yeah,
Jake, did you want to add?
to the extent that, you're talking about public institutions that are established before the state, William and Mary, University of Michigan or whatever,
Yeah.
so long as they are public institutions that are governed by that state, they would be covered within
Yeah.
this. Yeah.
Some were private institutions at their founding and became publicly.
Sure. But if they're now operating under state authority, I think, yeah, they would be covered within this.
Right. That's the clarification. Okay. And then the part more for Jennifer is, Jennifer, if you go into the boards of public institutions and public systems, because in some cases the institutions have boards, in some cases only the system has a board, there's a variety of models. There's appointed by the governor, there's appointed by the legislature, there's elected by the people. And then there are even some cases where there are some privately self-perpetuating seats because of a historical agreement. Clemson University being an example in Clemson, South Carolina. So this is the operating procedure right here, right now. So I don't see this as being a change or different. And so.
Thank you, Mark. Rebecca, you have the floor.
Okay, so I had a couple of questions going back to 602.23H. There's a provision in here around contracts, and I'm curious, do the agencies have to make sure that the institutions and the programs are complying? And like, what if they believe they're violating the law? And like, what does that mean, the selection of contracts? It's on page, yeah, 94. We kind of skipped over it. H.
We skipped over because we didn't change that from the previous draft.
No, I feel like this is a very serious topic for my constituency. Like, do the institutional and the programmatic accreditors have to ensure this is the case? And if so, Jacob?
Yeah, so what this says is basically the agency can't require the institution to adopt policies requiring, or basically that would require the institution to violate federal law in regard to these things. So it's not requiring the agency to go out and police the contracts of the institution.
Okay.
It's saying the agency can't require the institution to do something that would otherwise violate federal law.
Thank you, Jake. Any follow-up, Rebecca?
Yeah, well, I'm concerned too with I had this collusion component, which we previously talked about. Like, what does it mean to have collusive activities? Like, how are we going to define that and really ensure compliance around this? I mean, that's an open-ended statement. Like, how are we going to deal with
Please, Jake.
So this is part of the broader antitrust discussion in here. Collusion is a product of antitrust law. It's a whole established area. Defining it is really a matter of, well, what the courts have said counts as collusive behavior. We can't necessarily define it explicitly here because it's something that's created by courts and it can take different forms. This kind of comes into where we were talking about interlocking. You brought up earlier concerted or joint actions by accreditors. This is all part of that thing. But when we're talking about collusion writ large, that is a product of antitrust case law. And this is basically, we're not defining it here because it's not really our place to do it. This is something that DOJ does as part of their antitrust area. But we're saying that basically we don't want accreditors, it's an affirmative statement that we don't want accreditors adopting these policies that would be considered as collusive under antitrust. And that largely means, blocking other people out, doing anti-competitive actions, that kind of stuff.
Okay, thank you.
Thank you, Jake. Thank you, Rebecca. Magnus, you have the floor.
Yeah, I want to apologize in advance because I'm actually, I have a question about this section, but I'm actually looking at 22 first, and just sort of broadly. So there are some changes related to requirements surrounding change in ownership. And I think that there's a lot of risk to students when it comes to change in ownership. So I sort of want to invite some discussion from some of the accreditors at the table to kind of weigh in on this too. But I think that the department's goal here is to reduce burden ultimately, right? But these ownership are not just, these changes in ownership are not just technical changes. And we live in a time where a lot of institutions are under a lot of financial stress. And a lot of times when you change ownership, that can have significant impacts on the amount of tuition that's charged to students, on faculty, staffing in general, but faculty pretty heavily. the academic programs that are offered or not offered at the institution and the institutional finances overall. So I'm just sort of broadly concerned about changing the requirements as it relates to getting accreditors involved.
Yeah, the accreditors are involved. I mean, my reading of the changes that we made here is that we took out the term substantive, so it's any change in the legal status or control or ownership of the institution triggers the substantive change. So I think we've actually we've provided more protection in a case of a change of ownership by removing the change substantive. So it's like it's any change.
Jake, did you want to add to that and then Magnus follow up?
Yeah, building off of what Jeff said, I mean, this does actually require the accreditor to have policies regarding any changes of ownership and also the establishment of additional locations. Changes in ownership are a very prescribed system in terms of the department's regulations. We have, whole sections on identifying changes in ownership that result in a change of control, as opposed to just a simple change in ownership where there is no change in control. This actually expands what it's currently there to require the accreditor have policies for, specifically change of control as well as change in ownership. And I don't think we're taking away any of those protections. We're very cognizant of the risk involved in that. And especially, as you said, institutions are undergoing financial pressure. We're seeing more institutions engage in CIOs. It's something we look at very carefully. I spend 80% of my time working on that. So it's very much something that we're not giving a lack of thought to. And that said, accreditors already play a very heavy role in that process. Accreditors have to approve changes in ownership as a part of our approval of the change in ownership. So this is all baked in there already. We're actually building in a little bit more.
Thank you, Jake. Magnus, any follow-up before I move on?
Yeah, I invited the accreditors to speak and I saw Michael's card go up, so I'll defer to him. And I have another question, happy to go back in the queue about 23.
Michael, you were up. Thank you.
Well, I guess I don't recall where we were. So I'll just, Magnus, just on the change of control bit. I mean, I see your point. Effectively swapping out substantive and defining that as change of control. I mean, as I read the change here is that it's any change in the legal status, form of control or ownership of the institution that results in a change of control. So those are the ones that would be and so you're right. There can be a change of control or change of ownership that does not result in a change of control. An individual might own 65% and then through a series of acquisitions might only own 40, but that could still be the controlling interest of the institution. So it's when that change of control kind of swaps over and there's a new controlling entity or entities. That's, ultimately what the largest concern is. The other concerns that you're bringing up, however, about, there could be changes that could impact the financial condition of the institution, but those would be captured in the ongoing annual monitoring of the finances. So a modification and change of ownership won't produce any greater review of the financials. Now, my agency and many others do require reports on any modification to the ownership, but we're most concerned about changes of control because that entity is now the one that has the ability to, in fact, control the actions of the institution and make decisions and determinations. So you're still going to get the same level of monitoring, however, through just the normal processes, regardless of whether a change has occurred.
Department, Jeff, please.
Just quickly, and if you look at the bottom of page 80 under E, there's also, if there's an acquisition that doesn't trigger, otherwise trigger, there's a review there as well.
Oh, yes, I see.
Thank you, Jeff.
Thank you so much.
And then Jake, did you want to add to that as well?
Yeah, just touching on something Mike said that I think is a really important point. When the department analyzes changes in ownership, a change in ownership is different from one that results in a change of control. That doesn't always mean you own 51%. You could buy 40% and have some kind of control right baked in. So this really covers, it brings the standards for accreditors in line with the department standards for analyzing changes of ownership with changes of control that look at factors beyond just economic ownership.
Thank you, Jake. Magnus, we're back to you.
Yeah, great. I really appreciate all the discussion on that. Thank you so much. So I did have a question about like what happens when states have different state laws that, and of course the department has removed the regional aspect from accreditors, but there are 50 states in the nation and they all have different laws and some of them conflict. California may have vastly different laws than Ohio, et cetera. So by mentioning state law in here, are you thinking that an accreditor would have to come into compliance and track state laws in all 50 states at any given time in order to meet that requirement?
Please, Jeff.
We're talking about the governance piece, right, dear? Yes.
The governance piece or the contracts piece that Rebecca brought up?
Okay. Yeah. So on the governance piece, yes, they are all going to be different, but since that's basically the policy of the institution, the accreditor already has to know the policies of all the institutions that they accredit anyway.
Thank you. Michael, did you want to add to that?
Well, I mean, I would say it slightly differently insofar as one of the charming aspects of our system is its decentralized nature. And so 50 ways of doing everything. But the accreditor is not responsible to know it all. The institution is responsible for its compliance in its area of jurisdiction and would have to demonstrate that compliance to the accreditor. So I may not have off the top of my head all 50 different kinds of refund policies that might exist, but I do know that that institution has to demonstrate to us that they're complying with California's requirements or Minnesota's requirements or whatever the case might be. And then on top of that, if there are conflicts typically, then I mean, the rule of thumb, and I think that's fairly, if not universal, then largely held, is that the more stringent policy always applies. So if there's if the states say do refunds within 90 days and the feds say 30, then we're going to defer to the more stringent policy of 30. That's typically how it works.
Thank you, Michael. No other cards at this time, Jeff, so I think we're ready for our next section.
Okay, I think we're going to go back to 95, page 95. And the next one would be K, which is, I believe this was a suggestion from Jeffrey Bottomer.
And I do want to say, I think that we took his idea and put these words together. So if they're not correct, like he had an idea and we were taking it. And so I'm trying to be cognizant of, when we've taken ideas and added to them. So.
Thank you, Jeff. Thank you, Beth. Michael, would you like to get us started, please?
Well, I'll just say, and Dr. Barker mentioned this earlier as one of the concerns being the race to the bottom. One of the provisions is that, revocation and probation and those kinds of actions are not going to be a reason that the secretary will determine changing accreditors to be one of the determining factors, unless it's found to be that they're trying to, evade law or an accrediting action. And so, it just creates more opportunity to say, now accreditors must have an accelerated process for changing. Like, again, in a free marketplace, those agencies that choose to do that can do that. But to have a must foisted upon them, I mean, to what end and for what purpose? And so if agencies want to do that and it doesn't have an impact on their ability to assess the quality of the education, and they can demonstrate to the Department of Education that they've made a determination. Because this is the other bit, is that for an agency to maintain its recognition with the department, it has to make a determination that an institution meets all of its standards, regardless of whether it's accredited by another agency or not. So now we're going to compress that and accelerate it. And for what purpose? It's a voluntary change of accreditation. Why would we want to reduce the risk and the gatekeeping capacity of an accreditor to ensure that this is not an institution that is in fact trying to evade an action from some other agency? What is the urgency? They're already accredited by another agency. So why are we creating an urgency to get them through a change process unless they're trying to, again, evade a standard or for some other purpose? I don't understand what the purpose of it is, because there's no expediency, or there's no urgency around, well, they're not eligible for Title IV. But they are, because they're already accredited by another agency. So what would be the purpose of requiring agencies to have an accelerated process?
Thank you, Michael. Jeff and Jake, can we hear from you on this?
Yeah, I think the notion here, Mike, was to encourage competition. And so to the extent that it's too much of a barrier to move from one agency to the other, I think that's the problem we were trying to solve for. If I understood Jeffrey's suggestion, was that we talk about, yeah, they can move from this agency to the other agency. We want to bring more agencies in. We want to make sure there's a good fit. But if everybody's in the back of the queue and it takes several years for it to happen, we're not really encouraging innovation and competition in the marketplace.
Thanks, Jeff. Jake?
Yeah, just a quick add-on. I mean, we're telling agencies they have to have a procedure to accelerate the process. We're not telling them what that procedure is. To the extent that agencies, have different time frames and look at different criteria, that's kind of their purview. We're just saying you have to have a process in place.
Thank you, Jake. Jeffrey, did you want to add something? Okay. Jennifer?
At the risk of probably not getting a great reply. In my experience, so we're seeing, thanks to the good work of the department back in 19 or wherever it was, we're seeing institutions moving. They're actually moving. I mean, I've been sort of surprised, to be honest with you, with the speed with which the accreditors are working with one another to make the switch. Where I actually have witnessed directly a slowdown is at Ed. So like I said, I'm just saying that in my experience, which is direct with direct knowledge, I'm aware of situations where both accreditors are good to go and things have sat at FSA. So I hadn't really thought about this provision, sort of like whatever. But now I'm kind of leaning towards Michael of saying, well, I mean, there should be expediency everywhere. If we're going to do this, like, we could say that the department has to make a decision within a certain amount of time.
That would actually be something we would consider.
Okay. I mean, I'm just saying that in my experience, the accreditor piece hasn't been an issue. I will say this, to Michael's point, you were talking about sort of the review. This might change my view on the 3-year monitoring, because if we're going to do a speed dating situation where schools are just easily able to move from one to the other, then I actually would say, as a member of NASICA, I might want to see that agency back more quickly. So this does have direct impact to some of the other, and I think, Michael, you touched on it in a different context, but this provision touches the other provisions that we already discussed this morning. They all need to work together. So I would be hesitant about, sort of allowing this provision and then softening on the 3-year piece.
Thank you, Jennifer. Anything additional, Jeff, before I move on to Michael? Okay. Michael, please.
I mean, I think that the better approach is a may. But the may is there purposefully to say you may do this, and because what you're really doing is you're essentially creating a different set of policies in this circumstance, and we're okay with that, right? So it's okay to have a dual set of policies, but to put a must in there, while I understand that there may be today some desire to encourage behavior, I don't think that that's what the Higher Education Act mandates and establishes as a provision for accreditors to do. And so while I respectfully I appreciate that you read that the Secretary establishes the criteria, but changing accreditors is not one of the considerations that's part of the Higher Education Act, or facilitating that or creating choice. So, but I do think that if agencies want to do this, they should do it really well. And I do think the department should review it and make sure that, yes, in fact, this accelerated process still requires accreditors to hold those institutions accountable to demonstrating compliance with all their standards, and not just relying on, well, they just got a 5-year grant or a 10-year grant 2 years ago, we'll just rely on that. I don't think that would meet the spirit of the criteria that's otherwise set forth in this entire section.
Thank you, Michael. Mark, you have the floor.
It's really just a clarification question. So since part of this hinges on FSA, does the move of FSA to Treasury impact any of this? So they will still be accountable to the department?
The agreement between the department and Treasury is an interagency agreement under the Economy Act, which basically gives an agency the ability to essentially contract with another agency to perform those activities on behalf of the department.
Thank you, Mark. Thank you, Jeff. We're ready to move along. There are no additional cards at this time. I take that back. Michael McComas, you have the floor.
Are we? No, I'm moving on.
You are moving on. All right, Jeff, can we move on?
I'm going to defer to Beth on this change.
We are moving on to L. Beth, you have the floor. Perhaps it's not L.
Sorry, we did have one more change after this, after that paragraph. So this is paragraph L. And this is a suggestion that we got from the public institutions, and the proposals on page 26 of the proposals that came in.
Thank you, Jeff. Michael, please.
So this is L. And I feel like there are a lot of words here to say simply that we want faculty or students or others to have an opportunity to participate during onset evaluations. Am I synopsizing that close?
Yeah.
Is that the import here?
I think that's a fair.
Yeah. So
A structured opportunity.
a structured. So right now, typically agencies have to provide what's called a notice of agency or of institutions that are coming up for review. So that goes out, but hard for students to find it. Sure, hard for anybody to find it if you don't really know what you're looking for. Agencies typically do student surveys, but those may be anonymous. They may not in any way actually impact. I just think that if this is a direction that the committee agrees would be useful, I don't think that the accreditation community is kind of against the idea of it. I just think that we can compress the language down to site visits should include an opportunity for engagement with students and faculty and other interested parties at the time of the visit, or something like that, into 1 or 2 sentences.
Thank you, Michael. Rebecca, you have the floor.
Yeah, I want to comment on the same one because it talks about concerns. And I think that word, it really correlates to the institution's complaint policies, the accreditor's complaint provisions, which are written in other standards. So do we need to have the word concerns? Because this is really just about them communicating during the on-site evaluation. And so I think there's some overlap here. And, the agencies already have their own complaint processes, and I just think we have to be careful how this is rewritten because it's a lot for a team to consider.
Thank you, Rebecca. Jake, did you want to speak on that?
Yeah, I think part of the reason we wrote this out as long as we did, instead of just saying, opportunity to meet, is we don't want institutions to be able to meddle with an agency's review to some extent. That's why we put in this provision that, an agency could choose to use randomized panels. So the institution can't use some mechanism of choosing which students participate and don't. Certainly, agencies might spread around that, you can come and talk to us and whatnot, but an institution might attempt to prevent its students from doing that. And that's also why we use concerns here. The complaint process exists, but we're also aware that people don't always follow the complaint process and that institutions sometimes attempt to prevent students or faculty from making complaints. This is kind of a guarding mechanism to some extent. And the use of concerns was very intentional for that purpose.
Jeff, did you want to add to that?
Yeah. And I think it also, to your point, Michael, because it's include but not limited to, it does give you options, but we want to signal here particular types of activities that we're looking for. Now you can have other activities under this language, but particularly I think one of the important ones for us is the randomized panels. Because a criticism that we often hear is that the institutions select who the accreditors meet with. And we want to see more average students and faculty members having access to that process.
Thank you, Jeff. Magnus, you have the floor.
Yeah, I'd like to express appreciation and echo a little bit of what Jake said, because I'm not the type of student that you want being the only type of student represented in those panels. You want your welding student, you want your auto shop student, not just your public admin student who knows how to talk. But also I think this could be expanded if we're thinking about changing the language, not just limited to on-site visits. There should be some structured mechanism for students or staff or faculty to be able to communicate with the accrediting agency in a very transparent, clear, easy to find way in order to prevent the buildup of ongoing issues. Because a site visit is I think HLC is once every 7 years or 10 years or something like that. I could be wrong. Please correct me if I'm wrong. But if there's a way in addition to on-site visits for communication directly with an accrediting agency to be built into this, I think students would be really highly supportive of that.
Thank you, Magnus. Jeff, did you want to add something before I move on? Okay. Michael, you have the floor.
I think you're just talking about complaint policies. Which are heavily layered throughout, and not only do institutions have to provide that as an option as part of their complaint policy, accreditors have to have a process by which to do that, and so it's in another section here, but it's not just limited; it's anytime. And so I just want to make sure, Jeff, to your point, it is an or though. Right? 1 and 2 is an or. So randomized panels, that is one of two options. You have to at least choose one of those two, but you can have as many others as you might like, if I'm reading this correctly.
So the lead-in is permissible mechanisms include but are not limited to any one or more of the following. So there's even additional ones on top of that.
Thank you, Jeff. Michael, did you have anything additional before I move on? Thank you. Rebecca, you have the floor.
So I just want to comment, having done a lot of visits, that it's not just a handful of students that are selected during a site evaluation. Technically, the team can talk to anyone they choose at any time, open any file cabinet, look at any document, look at your federal financial aid documentation, pull the institution's financials. So writing this into this section, to me, having done a lot of business, like, whoa, do we really need this? Because honestly, accreditors train their site evaluators to do this stuff, to seek out students that are standing in the hallway. Maybe they're not like approaching them in the bathroom, but believe me, if they sniff an issue in an institution and they're there to look at one program and it sort of like spirals out into other areas in the institution, those evaluators oftentimes will call Mike and say, hey, you know what? I think we're going to extend our review and evaluation in this area. And more importantly, when students file complaints, when administrators file complaints, when evaluators file complaints that make their way into an accrediting agency, more often than not, those complaint issues are addressed during a site visit to make sure the response that was received from the institution is fully rectified. So in my opinion, this way, way overreach. Like they send surveys out to as many students as possible. Like there's so many processes in place to cover for this. Now Mike's gonna have to write some, and the programmatic, some randomized review. It just seems like a lot.
Jeff, did you want to speak on this? And then Jake, I'm headed to you.
Yeah, I guess the point, while I don't doubt that some teams go in there, I think there's a general perception, and it comes back to us that students and faculty don't feel like they have full access to that process, and so that's why when Dr. DeCastro, sat down and really laid all this out, we thought it was very consistent with what we hear in terms of general complaints about the site visit process, and so that's why we opted to put it in while still maintaining some of the flexibility. But they're clearly, I mean, my own experience is you probably don't see a cleaner college campus with better landscaping than when they have a site visit. But again, to that point, I do think there's a perception out there. And we do think that this signals at least our response to the perception from the faculty and from the students.
Thank you, Jeff. Jake, did you want to add?
Yeah, I mean, to the extent that your agency already has a policy in place, you're good. If it lets you go talk to any student on campus at any time, that's great. I think this is to cover where, accrediting agencies don't have that in place. And moreover, basically it protects accreditors to some extent. It basically says that, you're putting these policies in place, and as a condition of being accredited, you have to let us talk to students or follow these policies. And I think, Dr. DeCastro's proposal really does a lot of that stuff. And I think Magnus articulated this really well. Students do not necessarily feel heard in this process. And by enshrining this here, I mean, this is not going to be a full Festivus airing of the grievances that we're requiring accreditors to hold, but it does provide, some, we want there to be some actual guidelines and procedures that allow students during site visits to actually give some meaningful input and not necessarily feel that their institution or somebody is staring down their back while they're doing it.
Thank you, Jake. Thank you, Rebecca. Mark, I'm over to you.
So I want to thank Rebecca for giving me PTSD from past site visits of an accreditor that literally would walk around campus and stop students at random and ask them questions. And they may be being asked a question about an issue that they don't actually understand, standards, et cetera. So my point of clarification here is that the purpose of this is to focus on questions that remain from the self-study, that these are focused discussions. This is not a general, how do you feel about the dining hall, or whatever may be the case. But because that's one of the challenges we have with some of these methods is you're stopping individuals and asking them questions about things that it's like stopping somebody who's never driven on a road and asking them what they think of, the traffic laws in Washington, D.C. as compared to Boston or whatever. This is not a trivial issue to get to those substantive issues. So I think, or at least I hope what you're saying is this would be structured around a narrowly tailored set of questions so that it is indeed substantive.
I think that's the idea of having a procedure in place, right? It basically lays out, it puts some rules for what the accreditor's looking at, so the institutions have an idea of what they're going to be doing with this process, but it also provides accreditors cover to actually ask these questions and get to meaningful answers, and students a meaningful opportunity to give input.
Thank you, Mark. Thank you, Jake. Magnus, I'm over to you.
Yeah, Rebecca, I just want to say I deeply, genuinely appreciate your perspective. So I appreciate you adding that in. But additionally, I do agree with what Jeff and Jake have said. I do think this is a rather opaque process for students, and I agree with Mark. I do think the intent here is to have a very structured way to interact with students in a way that can be understandable to them. And also, when I mentioned maybe building in a way outside of site visits to do this, I would say, Michael, this might go beyond something like a complaint policy where there can be direct structured communication with students between site visits. I don't know if that's possible. Maybe I'm an idealist, but I often say that as a student representative, I'm entitled to some idealism, some naivete. So that's I'll just add that to the discussion, food for thought.
Thank you, Magnus. Michael, I'm over to you.
I'll come back to that. So a structured mechanism could also be surveys, not listed here, but I think can be far more effective. I mean, depending on your response rate, but can be far more effective than just a panel or a registration process. So I would encourage you to have maybe one of these three in that surveys that are conducted by the agency, not by the institution. Right. And so, and that, you can get far more, I think, reliable information. I understand the issue of let's just send up the student council, or send up, those students that are really, engaged. It's also not necessarily helpful to just stop a student on the quad and say, did you enjoy the D that you got in your history course? And so, and look, I've been doing this a long time. As much as I would love folks to share just out of the goodness of their heart all their positive things, that's not what happens. People only reach out, students, typically faculty, whomever, typically reach out when they're upset about something. So even if we were to set up a mechanism like this in the middle, it's unlikely that we would get a lot of feedback about what a great job you're doing. It's one of the thankless parts of this career field. So I would just encourage surveying can be far more effective than just some of these limited things. And so maybe adding a third, it's still a menu, but surveys conducted by the accreditor, not by the institution.
Thank you, Michael. Okay, David, you have the floor.
Yeah, just a quick practical note on randomized panels. Unless we're intending to require them to attend, then that randomization is going to go out the window immediately, and you'll have whoever selects in, which then undermines the last piece, ensuring a representative cross-section. So you'd have to actually require them to have that happen.
Jeff?
But I think if we took Mike's suggestion on the surveys, we may be able to get a representative sample through that mechanism, given, depending on the response rate. So we may be able to mitigate that. So I appreciate you bringing that up.
Jake, did you want to
Yeah, I
add?
think randomized here really just means not selected by the school, to the extent that, it's a randomized group of people who are asked to participate. Yeah, to Mike's point, not everybody will show up. And in terms of pure statistical randomization, concede you're correct. But it really means that the accreditor is not specifically picking individual students, and likewise, the school isn't controlling who is actually showing up for those meetings.
Thank you, Jake. Any follow-up, David? Okay, thank you. Jennifer, you have the floor.
Yeah, I would just delete randomized, and along the same line, I like Michael's suggestion of adding surveys because the way this is written doesn't really contemplate online. I mean, it does because you can do the things that are, so I think surveying is a good idea. You can do panels online, obviously, but it's a little harder to get the, to select the student. Like everything is a little bit more of a challenge when you're talking about a national. So I just wanted to put forward that there's also a technology reason to really support surveying.
And again, because these aren't the only options, there's room there for that kind of innovation and those changes. So, Kayla, I'm going to try to pick up the pace because I'm looking at my watch and I'd like to get a caucus in at least today. So we're going to try to go a little bit faster through this.
That sounds great. We have one last card, then we will move on. Magnus, did you have something additional?
Yeah, just very brief. I agree with the idea of surveying, but I just want to make the point that I think this particular section is really important for new accreditors, because part of the goal here is to encourage new accreditors to pop up, and having something like this in the regulations will encourage, will help new accreditors form their own standards around these types of communications with students. So that's.
Thank you, Magnus. Ray, would you like to switch places? Is that what we're doing? Okay. All right. Thank you very much. So for state officials, including governors, we now have our alternate coming to the table. Thank you. Julie, the same thing? Okay, so for veterans, we're also going to bring our alternate to the table. Welcome, gentlemen. Jeff, I'll turn it back over to you to move us on.
Okay, we're going to jump up to page 99. There's a technical change at the top of the page, adding in 30 days. Beth, do you want to talk to that?
I just wanted to say we added a similar within certain amount of time requirement in 60224C3. So to make that aligned, we wanted to have a deadline under C1 as well.
Okay.
Okay, thank you, Beth.
Yep.
Oh, we do have one card. Stuart, please. Lingering. Perfect. Jeff, back to you.
Okay, skipping ahead to 102. Put some language in there stating a plan to maintain and provide access to transcripts in the event of closure. This was from the student and veteran negotiators, is my understanding. And I'll let everybody get to that point, and I'll let Magnus and Stuart confirm that that's consistent with what they wanted.
Thank you, Jeff. Magnus or Stuart, was there anything that you'd like to say about this particular piece? Please go ahead, Magnus.
Yeah, I think there were some minor suggestions from us that may have been incorporated here, but I think a good amount of our proposal maybe was not incorporated here. So can you explain what the rationale was by not taking those sections?
If I was going to go on all the ones that we didn't take, we would be here for a while.
Sure,
So
sure.
we took what we thought we could take, and where we thought we wouldn't lose folks around the table.
So I think our main concern is that a teach-out institution, it needs to be ensured that they have the experience and resources to provide a program that's reasonably similar or of acceptable quality, and it has the capacity to carry that out. And I don't know that that's reflected here.
Okay.
It's in another area.
Yeah.
Okay.
Yeah, in this part, it's just the agencies just evaluating whether or not the plan includes a list of institutions offering similar programs. The capabilities discussed later on.
Okay, thank you. And there are no other cards, so I'm going to suggest we move to the next piece, Jeff.
So the next set of changes is transfer of credit. That's one that we have identified for the first caucus. So if people can hold their issues and concerns on that to the caucus, we would greatly appreciate that. So we can move to the next one.
Michael, are you able to hold that to caucus?
Well, just quick, thank you. Okay.
So quickly.
On page 106, under, I didn't know we had moved past that. So 106 on closed institutions, based on our last conversation, I had mentioned that I think you meant to accept my edit, but you did it backwards, or maybe not. I had suggested that you strike or agreement and go with teach out plan. And the reason being that for institutions that are closing that have, they're just closing an additional location, or it's a controlled closure. They're going to teach out their own students. They don't enter into a teach out agreement, but they might have a teach out plan. And so now there are instances when there's a precipitous closure. And if that's what we're trying to get to, then I would almost recommend that we have a separate definition as for precipitous closures, or those institutions that close without either a teach-out plan or a teach-out agreement. But for those that are just controlled closures, we're winding this facility down, we're winding down this location, requiring all these other things is really not necessary. And I think it also, by requiring the teach-out agreement, there are other issues that go along with closed school discharges and other kinds of, FSA stuff that I won't pretend to know all about, but I know there are intersecting details there. So again, my suggestion had originally been to just keep it to teach out plan.
you, Michael.
Yeah, I thought that we had worked out all the kinks between plans and agreements and when they weren't. So it sounds like we still got a little bit of work there. So we'll work with you on that and make sure we address it. But this is to address all situations when they're invoked. And I think in the prior draft, there were a lot of instances where we were referring to agreements where we really meant to be referring to plans.
Thank you, Jeff. David, please.
Yes, thank you. And thank you for doing the caucus on the transfer credit. That's obviously a big deal for us. I just had a clarifying question before we get our waterfowl collinear. And that was about the parameters within which we can operate. The Higher Ed Act, Section H, seems to put a prohibition on these rules requiring particular policies, procedures around transfer credit. And I know you've thought about this already. I just thought it would be good to know what we're operating with.
Sure. We read the statute as well. First of all, we wouldn't propose anything that, in our view or the view of the attorneys and throughout the federal government that review this, would violate it. We're not prescribing transfer of credit policies. We're talking about the application and the results of those. So we think we're on the right line of transfer of credit, but it is a significant enough problem that we will be very aggressive on this topic. And if anyone wants to challenge this and require and go to court and require people to take credits and spend money and waste time on credits that they've already earned, we're more than happy to have that debate in the public square with them.
Thank you.
Thank you, David. Thank you, Jeff. Let's move to our next section. Where would we like everyone to direct their attention now?
So the next set of changes is 113 and 114, but that's separate and independent transfer of credit that was added in due process. So we would like to have a separate caucus on that. And one of the things we'd like to discuss was whether there's other places in the regulations that some of these provisions could be handled.
And I believe it's actually 113 through 119.
Yeah, I'm sorry, 113 and 119.
Okay, noting that we're going to caucus on that, should we continue moving along? And I will note that we're about 20 till the hour. Are we going to take an afternoon break briefly? Do you want to do that now?
Let's try to get through the rest of this, take our break, and then come back and do a caucus after the break.
Sounds good. Where should we direct everyone's attention next?
Page 122 down at the bottom. This is related to other changes that we made on behalf of the student and borrower representatives. And this gets at notification with regard to accreditation status and accreditation decisions.
Does anyone have any clarifying questions for this? Okay. Thank you all. Jeff, we can go to the next piece.
Bottom of 123.
Going to invite questions and comments. Jennifer, you have the floor.
I appreciate this is another one like the one earlier today, that other H. That I appreciate the department listening from session one about our concerns about the department's role in sort of, I was going to say overturning, but impacting the role of the accreditor. I do, though, have a suggestion on this one, which is I would really love it to not say if the department believes the agency violated its own policy. It's a little judgy. I think that you could actually have a period after, and I'm looking at it and looking at my notes, making sure that I'm being correct or accurate to myself, but I think you could end it just at has concluded.
Yep.
Like you could put a period at has concluded and you'd still have the exact same impact because actually you're giving yourself discretion by putting the period after concluded instead of having this whole. Because if the point is that you want to be able to continue Title IV, which I totally understand, while a review is going on, then you can do that without the judgment of whether the agency did something wrong or not.
Thank you, Jennifer. Jake, do you want to speak to that?
Yeah, this one, you're right. That would give us more discretion. I think this is a balancing act. This constrains us a little bit. We don't want the department to be able to provide Title IV access to an institution that's lost accreditation writ large. We want it to only be where we have reason to believe that the agency violated its own policies. We want that to be a narrow situation. I understand your concern about the judginess of the language, but this is fundamentally a judgment regarding the agency's actions here. And we don't want this to be opened up to, the department can continue to allow Title IV access to a school ad infinitum after they've lost accreditation. We only want this to be in certain situations where we actually believe that the agency violated its own policies. Although I think we're probably open to other language.
Well, because everything you just said is completely controlled by the simple word may. You have may. So it says the department may continue. So you can decide that you don't want to continue it. So you have the discretion in the word may. We don't need the process because I don't even know what the process is for the department's determining whether it believes something or not. So I think you just
Yeah.
cleaner to put the period after.
Well, and we'll take, I'm willing to take a look at it. I think we're also willing to take a look at maybe a more neutral term, but I get, again, the concept here that there's a matter that's under dispute, and the revocation of accreditation is not necessarily final, in that case. So.
Thank you, Jeff. Mark, you have the floor.
It's real quick, but it's just the way I read this, and it's similar to Jennifer, is it's basically saying the department may continue Title IV funding if it expects the agency to lose its case.
Yeah.
Yeah, you've come to the conclusion that the agency was at fault even before it has had due process of law.
Yeah.
Okay. Thank you, Mark. Michael, you have the floor.
Yeah, I mean, I think that is very well stated, and using the word belief as opposed to determine, again, would at least determine would connote a policy or a practice, a procedure is in place. How else would the department know that the agency violated its policies unless a complaint was lodged against the agency to do so? And I think in my experience, what you're going to find here when you open this up is that every revocation action will be followed by a complaint to the department that the agency didn't follow its policies. Now, those same determinations are already afforded to the institution via due process in its appeal, arbitration, and potentially litigation matters. So why would the department need to insert itself into an ongoing process that's already likely occurring through standard due process to make some other kind of determination? And so, as I said before, and I don't know that every agency has the same policy, the ones that I'm aware of, in most instances, the institution does not lose its accreditation until a final action is determined, and that is after all due process has been exhausted. Appeals, arbitration, and again, if they take the agency to litigation, temporary restraint, a TRO, and then probably some kind of lengthy court case. So. And then lastly, I would just say, if you are going to keep something, then you should still have in your hip pocket a teach-out plan that's been submitted and approved submitted by the institution and approved by the agency as a condition of their continued eligibility to participate.
Thank you, Michael. Jeff, we've worked through the cards, so I'll go to you for response and then to move us to the next section.
Just quickly, the issue that we're dealing with, and I essentially push back on proponents of this language with that same rationale. And so I think there is the possibility, I was at least convinced that there are gaps in the process where an institution, before they can get a stay, for example, from a federal district court and get an injunction, there's a period of time where they are out. And it's that period of time where they are out and where the decision has been final, and they're not able to get it enjoined, where the department is forced not to give that institution aid, pending that, and then there's significant financial damage that can be done to the institution during that period. So and to the students.
Thank you, Jeff. Jake?
And this is where the believes language becomes important. We're not determining this on our own. That's the purview of the court. We want this to play out. But if we look at, the reason why a school lost accreditation, and there's like a pretty blatant issue that we can see where something went wrong on the accreditors, and this lets us continue that funding while it's playing out in the court. But we're not making the determination that it was improper because it's going through court or arbitration, and we aren't substituting our judgment there. We're just saying if we think there's substantive reason to believe that the agency didn't follow its policies, we keep the funding going until the process fully plays out.
Thank you. Michael, please.
I don't have too much of a dog in this fight other than to say I see a path for drafting and that I want to suggest, which is to say the department may, and the department shall consider the following factors in making that determination. So you can restrict yourself without stating a belief.
Thank you, Michael. Back to you, Michael.
Well, I would just say you're handicapping the decision at that point. If you're saying, well, we're going to continue this because we believe that the agency violated a standard, you're sending a signal to the arbitrator, to the judge, and the institution is certainly going to use that in their defense. And again, that would connote that you have given the agency due process to say what the violation has been and to defend themselves and say why they believe that it is not a violation. And so it seems to me that the weight here is that agencies are losing a due process right, and that institutions are being afforded an opportunity to maintain access to federal financial aid despite all of the layers of due process that already exist, and keep their eligibility intact. Even if it gets up to the point of between a final action and a TRO, typically that's a week, 2 weeks. It's likely de minimis in the length of time. If the institution is continuing, if it's closing, that could be a different matter.
Yeah, that's actually not our understanding of it, and not the experience that it's that, and that's hence why we're here. And again, we don't have to invoke it until it's a point where we are required to withhold funds from the institution. In fact, we think it actually puts the accreditor and the institution on equal footing, because if the accreditor makes a mistake, fails to recognize that mistake, continues to process, the institution's now out, and they can calculate whether or not that institution has the resources to continue to fight it or to get a restraining order on it. So we think this actually helps level the playing field.
Thank you, Jeff. Mark, please.
So I'm going to go back to where Jennifer started. I think you should put a period after concluded, because what comes after concluded, if I was a judge, it is prejudicial.
Yeah.
It is going to figure into the litigation process. If I'm the attorney for the institution, I'm going to say, look, the Department of Education already believes this, so how could you reasonably not believe, the facts? But if you put a period after concluded, you're not prejudicing the legal process.
Thank you, Mark. Michael, please.
A couple points. One is that I think it's really important to remember who you're trying to protect here. And this is literally about the students that are in that institution, which may or may not have been adversely judged. And so this is erring on the side of the students for continuity of their program. So, I think part of that, is something we need to keep in mind in weighing the balance here. On the backside of it, if you got rid of those qualifiers, then the department would be functionally obligated to not suspend as long as the institution has some plausible world where they can sue. And I think if there's a sense that the process was fair, there's no allegations that it wasn't, that they weren't following their own procedures, then acting at the point of judgment is appropriate. Whereas this would seem to then create this kind of second category of waiting period afterwards. It's just a technical question, but it seems that would be the case.
Thank you, Michael. I'm going to call in one more card and then we do need to move on. Jennifer?
Yeah, I would just say that, Michael, that it's actually a kind of a crapshoot for the students in terms of the pros and cons. And I'm just being really genuine. We've seen plenty of examples where the department continued Title IV and then the school closes, and that's not to the benefit of the students so it's actually that part of the judgment part is, in fairness to the department and everybody else, it's really, I feel badly for the student, but it's not necessarily a good thing to continue the Title IV either. It's very much a crapshoot, but it's a crapshoot that I think is very much between the institution and the accreditor and the courts, and less so with including the judgment of the department until the process is finished.
Thank you, Jennifer. Jeff, I'm back to you for any response and then to move us on to the next section.
Yeah, and again, this is discretionary on the part of the department. We're obviously not going to throw good money after bad in those scenarios, but our hands are tied in a scenario where we do see potential harm to the students, and so we wanted to rectify that.
Where should we go next?
132.
Turn your,
This deals with the situation that we dealt with earlier with regard to it's a conforming or a complementary set of changes with regard to expansions of scope as well as contractions.
thank you, Jeff. Jennifer?
Yeah, two things, and they're both quick. Just on the technical on page 131, that's where this morning I said you'd have to have conforming language to the 3-year or whatever it is we decide on the 3-year for new. It's that A, I think, where you need to, and there might be other places, but that's the place where I spotted that there might need to be some conforming language about timeframes. And then I just wanted to thank you for the contractions as speaking on behalf of Nisiki, I think. We just saw this come up recently, and it's nice to have it in regulation, so I appreciate it.
Thank you, Jennifer. There are no additional cards, Jeff, so I think we might be ready to move on.
Okay, next one's 139.
I don't want to rush you, but I'm not going to belabor this. Does anyone have a comment or question on this piece?
Okay, if not, then we'll go to 143.
Jennifer, please.
Sorry, I'm back on just 139, and I just want to flag it again that I think, and this is just a flag, I'm happy to work on language, but in 1 and 2, which are not the highlighted, it's just the aggregate piece, substantial portion of institutional revenue. It's not clear to me. Is that by school? Is that all the schools that you accredit in the aggregate? Like, I'm not sure what one means. So I just wanted to flag that. I didn't catch it before, sorry.
We made a note. We'll talk about it tonight and get back.
Thank you, Jennifer. Jeff, once again, where are we looking now?
$143.
Great. Does anyone have any comments or questions on 143? I'm not seeing any.
One 145.
Just really small technical, but in 2, it needs to be clear because you have it being published. The agency must publish where instructions for how the public can submit information, but it's information that's going to be submitted to Ed, not the agency, right? Am I right about that? So you might want to reword that because otherwise the public's going to submit comments to the agency and not to the department.
Yeah. That section deals with information to the department, so we'll do that.
Thank you, Jennifer. Thank you, Jeff. We're looking at 145 now.
Yes. This is another one of the complementary provisions dealing with antitrust and anti-competitive conduct.
Rebecca, please.
Yeah, I know I'm like a broken record on this, but like what conduct exactly is the department referring to? And, that's violative of antitrust here, antitrust laws in this
Jeff?
section.
Yeah, so this could be examples of sort of what we talked about at the first set of meetings, the guild effect, where industries involved in the setting of standards for a profession where there's not a separateness between the industry and the accreditation. This could also be institutional accreditors that adopt and collude on policies with regard to geographic areas, consistencies in policies, and other potential barriers to entry.
Thank you, Jeff. Thank you, Rebecca. Michael?
Just a clarifying question on 145, what's now Part D. It says it only applies for initial recognition, and I was curious, is there language elsewhere that deals with anti-competitive behavior for renewal, or is there a decision why it was only affecting initial?
Good catch, Mike. I'm just gonna look at the edits there. So initially it was the current language was dealing with initial or expansion of scope. I think we meant to keep one of the commas on there. So I think it's initial or recognition as proposed by an agency.
No, actually, I think so. This would be reviewed when like somebody was coming for an initial or an expansion of scope to make sure that anything that they are proposing were to be any of these things would cause an issue with those. So we wouldn't look at it again when an agency is looking to propose either to come on with initial recognition or for an expansion of scope.
So there's no anti-competitive behavior review for continued recognition, like for renewals?
There's some, and so far as, the procedures still require, like, we would still require them to adopt procedures, in terms of like board composition and stuff like that, about the interlocking directors and other features that we talked about that still hit at this throughout the life of the agency. This part is specifically dealing with initials, but there would still be substantive requirements that prevent them from engaging in anti-competitive behavior that are baked in throughout this.
I would love to see renewal added to this. I don't know why it couldn't be.
Sure.
That's a good comment. Thanks, Mike.
Thank you all. Rebecca? Lingering card, no worries. Jeff, where would we like to go next?
Uh, 147. Looks like we had a couple there.
Yeah, 147 G1 is just changing slightly. In order for the processing for the department, it's much easier if we take 120 days from the submission deadline as opposed to the date that in which the agency might actually submit it. So then we keep everybody in the same cohort.
Thank you, Beth. Jennifer?
I guess, okay, that helped. Beth, I put my card up before you spoke, but now can you explain that a little? So the submission deadline set by the department. So the department is going to submit like just a date. Do you just mean?
We notify agencies of the date of when their petition is due. So the 120 days would start from that deadline date as opposed to if an agency decided to turn it in a month earlier or a week earlier. So it's not 120 days from various dates, but all the agencies would be on the same schedule.
Thank you, Beth. Thank you, Jennifer. Jeff, where shall we go next?
149. Yeah, 149.
Michael, will you get us started?
Well, just quickly, so just so I make sure. So if, say, for example, the agency's term expired in, say, February of 2026, but they don't get through the process until 2027 and they get the final recognition letter from the SDO, it would say effective February 2026 for 5 years going forward from that date. That's what you're getting at, right?
No, this is about your submission.
Oh, I'm on 149.
Oh, you've moved to the new one. We hadn't moved to that yet.
Oh, we haven't moved there yet.
But now we are. Okay, Mike moved ahead. That's fine. Yes. So
did I get that right?
Well, yeah, yes. So what it would happen is that, yes, I believe so. I wasn't actually totally paying attention to you because that wasn't exactly what I thought we were talking about. But yes, if your 5-year period has expired, the decision has not been made, or the department staff has not concluded the review, then your 5-year period would still end on that time, but you would continue your recognition until such time as a decision made. But then the 5 years goes back to the end of the prior 5-year grant. I'm not sure if that made any sense to anybody else, but I think Michael got it. So
It's the exact same process we use.
Thank you, Michael. Thank you, Beth. Anything else on 149 before we move on?
152. And these are corresponding changes with the expansion and contraction of scope.
Rebecca, please.
Yeah, I'm just curious, why would an agency need approval to contract their scope? Do they need approval to do that, or is that more a matter of notification?
It has to go through this, through the recognition process in this case.
Thank you, Rebecca. Thank you, Jeff. Jennifer?
I'll happily leave it at that. Do you want a more of an explanation? Okay. So at the last, I mean, this has come up a couple of times for us at Nisiki and for the department where we're seeing agencies have, for example, scope that includes doctoral, but they're dropping masters in their scope. And from a market-based standpoint, for lots of reasons, we don't think that from a policy standpoint makes sense. It drives, now it might be that the market is saying you have to have a doctoral degree, but we don't want the creditors to lead with that. If there's any hope that the market will say, we want masters. We think especially in this day and age where, speed to degrees is important, get students spend less money, same education. And so that's the argument is it seems like bad policy for the accreditors to lead with requiring a higher credential and dropping. So that's the contraction part, if they start dropping lower. Hopefully that made sense.
Thank you, Rebecca. Thank you, Jennifer. Michael?
Would this apply in such instances? So previously, my agency scope was for private institutions. And then when another agency lost its recognition with the department that accredited public institutions, we came to the department and said, we would like to be able to step in, take care of these institutions, but it would require us to add that to our scope statement. And so the decision at that time by the highly competent department staff was that was an expansion, that was not an expansion of scope, and they added it to our scope statement. And given this language, do you think that in that kind of scenario, that would represent an expansion of scope? And if so, then would you be open to a qualifier for a substantive expansion of scope or contraction?
Well, I'd have to go back to, your specific situation. I do know that we have made what we would call minor changes to scopes. I think that in your case, and please correct me if I'm wrong, is that you had previously had experience with not just private institutions, but others. And so it was more making it more representative of what you were already doing. And so that made it easier for us to do that. But I would have to see this case by case situation. And I was not the director at that time, but I think that we would have to take a look at what the request was to be able to determine whether or not, to your point, if it was substantive or not, and whether it was just a clarification of something.
So in that, do you think would it be useful here to be for a substantive expansion or contraction under A?
I mean, I think it would be good for us to take a look at that information.
Thank you, Beth. Thank you, Michael. Rebecca, did you have something additional?
Yeah, just a quick follow-up on this. So let's say I have a master's degree program. The state modifies the regulation whereby I have to have, a different level of credential. I still have to go through this contraction process and get approved to contract. If, state regulations change, would there be a time frame in which we could react to these changes in the job market, if you will?
So my understanding is if a state would change a requirement and it was a higher level degree, you would still have to come through for the expansion of scope. So the corollary of that is a contraction, same way. You'd come through. Either way, it's a change in the degrees that you're conferring or are approved to confer.
Well, just a quick question, Jeff. So if I'm a barbering school and I had a 1,300 hour associate degree program, but the state modified the provision to 500 clock hours, did that require all of the NACAS schools to apply for contraction in scope for that?
I mean, I don't think the scope of recognition goes down to the credit hour level. I mean, it's at certificates or degrees. So, I mean, if we had to look at expansions or contractions based on that, we would never get anything else done.
Yeah, if you went from a certificate program to an associate's degree program, yes, and vice versa, but not changes in the credit hours or contact hours.
Okay, I want to get to just these couple of lingering cards and then we will move on. Jennifer, please.
Yeah, Michael McComas, I think maybe, and I'm happy to work with you on it, but I think section 2 might be the place where you might get a tweak because it says at the discretion of the department staff and on a case-by-case basis, the department staff may review an application for an expansion of scope independent of the renewal application. Maybe there's something in there rather than in one. Just a suggestion.
Thank you, Jennifer. Rebecca, did you have anything additional? Jeff, back to you.
Okay, I'm going to turn this one over to Beth because these are a series of technical and conforming changes. So she can just go through them quickly since she worked on these.
I think we just have a few more to go. So on page 153, this is a similar change to the prior one in that we're talking within 90 days of the submission deadline or set by the SDO or secretary decision letter for the compliance report. That's the same type of thing to keep the cohorts together. I don't think there's anything about that. Then if you go to 160, I believe is the next change. And these are changes. And 160 is also adding contraction of scope to what the advisory committee can review. 161 is again the 10 business days of publication for the notice. It's the other notification. And I'll take the point back of making sure that it is to the department, not to the agency. That would be the same change here. Next up, I think the last two is 163 is also talking about contraction of scope. And then the final one on 168 is also related to contraction of scope. I believe those are all the changes that we said we would get through in the morning.
Best laid plans. Are there any additional comments or questions before we move on? I don't see any. Jeff, are you ready to take a caucus?
We'll have a nature break and then we can go to caucus right after that. The caucus is going to be on transfer of credit. We'd like to have it with the nonprofit representatives and those who submitted the comments with them, which I believe was Mike and the student and the borrowers. I'd also like to add the institutional, all the rest of the institutional representatives there. And the nascent accreditors, Jennifer, and the taxpayers, employers, and state folks can take a walk on this one, if you don't mind. And AD, I don't know where you fit in if you have a dog in this fight. Do you want to be in it? Okay, if you had it, okay.
Okay, so everyone's clear on the constituency groups that are participating?
And veterans, yeah.
And veterans. Okay, adding that to the list as well. We're going to take a quick break and then we're going to go to caucus.
Sorry, buddy.
Jeff, how much time do you think you'll need in caucus? Are we going to come back here?
Let's take it to the end of the day.
So we'll take it to the end of the day. We'll not be reconvening at the main table.
As hopeful as I am, I think that we got to deal with reality of the clock.
It's helpful for everyone to know that. Okay, and we're going to have this caucus in the first floor, or do you want to stay in here since we're...
We can stay here, and we're going to throw everybody else out here too.
Sounds good. Let's please take a quick break and then we'll caucus in here. Thank you, everyone.